Well, it's 12 on the dot, so I'm going to officially welcome everyone to the webinar. My name is Shannon Lawless, and it is my pleasure to be here presenting Ryan Swanson's 32nd Annual Employment Law Update COVID edition. So usually I look forward to this day every year because it's a chance to actually see my clients in person and to have lunch or a cocktail with them. And today, instead, I am joined by my cat, who is back here in the background making an appearance. So I miss all of your smiling faces. He's lovely, but you are lovelier. So the top 3 new employment laws you missed during the pandemic. Well, you know, even before COVID hit, this really was going to be a huge year for employment laws in Washington state. And, you know, this is about as suspenseful as it can get because I think, oh, they're all out there sitting. What did I miss? What am I not complying with? So, all right, here it is. The 3 laws we will cover today. So first, we're going to talk about the changes to the overtime exemptions, specifically a big increase in salary, the salary basis test, which happened federally January 1 of this year, and in Washington is going to go up a big jump January 1 of 2021. We'll go over that. We're going to talk about our state's new non-compete statute, and then we're going to talk about my favorite topic, paid family and medical leave. And for each one of these, we're going to do an overview of how the law has changed, and then we're going to wrap up with some action items. So let's talk overtime exemptions. So first of all, let's just start with a basic review. So an employer's fundamental obligation under the Fair Labor Standards Act federally or the Washington Minimum Wage Act here in Washington state is to pay minimum wage and overtime if your employees work more than 40 hours a week. There are certain types of employees, however, who are exempt from that requirement. You don't have to pay them overtime. You don't have to pay them minimum wage. And in particular, the changes that we are talking about today relate to the white collar exemptions, otherwise known as the EAP exemptions, executive, administrative, and professional employees. And to be exempt under one of those exemptions, employees have to meet not 1, but 2 tests. The duties test relates to the type of work that they are performing. So executives, that might be your CEOs or your managers, they have to be performing duties like have some hiring and firing authority, managing at least 2 FTEs. Administrative employees, that might be your HR professionals or your CFO. They have to be doing things that relate to the operation of the business and have a certain level of discretion and independent judgment. Professional employees, that could be teachers, engineers, lawyers, doctors, somebody with an advanced degree who's using it in their area of practice. So those are the types of requirements you are going to have in the duties test. That is not changing under the law. Not much, anyways. We'll talk about the details. The big changes are to the salary basis test. If you have an employee that has one of those duties and they have a salary of a certain amount that does not change based on the quality or quantity of work that they are doing in a work week, then they can meet the exemption. And the salary basis test is the subject of our big changes. So let's just take a look at an example. This is how it was in 2019. Let's take your executive employee, imagine the CEO. So they meet the duties test because they have all of these duties listed on the left-hand side. And in 2019, that executive only had to make a salary of $455 a week, which came out to about $23,000 annually. That number last changed in 2004. So it's been 16 years since this number changed. And of course, you know, cost of living has increased just a little bit during that time. So the federal government said it's time to change that. Now this, you may be thinking, gosh, I feel like I've heard that before. You did. So back in around 2015, the Department of Labor under the Obama administration had attempted to raise the salary basis to $913 a week, which was about $47,000 per year. And a federal district court in Texas actually stopped that regulation right before it went into effect. And so that increase never happened. But a lot of employers kind of got ready for the change back in 2016. So the federal government under in the Department of Labor under the Trump administration went back to the drawing board and came up with a lower number, $684 a week, which is about $35,000 a year. That was not challenged, and it became law on January 1 of this year. So, and there were no changes to the duties test under this most recent federal rule change. So now let's take a look at our executive employee again. In 2020, this executive employee has to meet that same duties test, but now they need to be making at least $684 a week to continue to be an exempt employee who's not entitled to minimum wage or overtime. Washington State is not to be outdone by the federal government. So our state Department of Labor and Industries went through a very hotly contested rulemaking process, and it came up with a phased increase, which I heard one employment lawyer call the slow march to 2.5 times minimum wage. I thought that was kind of catchy. So beginning January 1 of this next year through 2028, there is going to be a series of step increases up to eventually the salary basis being 2.5 times the minimum wage. That is the state minimum wage, not the city one. And that the rate of increase is going to be different and slower for small employers, that is, employers who have 50 or fewer Washington-based employees, than large employers. The one really, I think, bright spot for everybody, no matter how you feel about this change, is that the duties test in Washington, they used to be like slightly different than the federal duties test in really irritating ways that were hard to comply with. They are aligning those. So they are going to be similar now to what they are federally. That's great news. So let's take a look at the numbers. This is a chart that I put together based on a $13.50 minimum wage. So these numbers are actually a little bit lower than the real numbers will be. In fact, we just got the 2021 numbers in. I got the email from the Department of Labor and Industries this morning, and it's, you know, a little bit different. So, you know, maybe a few $100s different than on this chart. As you'll see, if you look over the increases for the years, the rules actually technically went into effect this summer, but the increase was less than the federal increase, so it wasn't effective. But starting January 1 of 2021, I'll give you the actual numbers that I got from L&I this morning. If you are a small employer, you are going to need to pay your employees at least $821.40 a week, which equates to an annual salary of $42,712.80. Or if you are a large employer, you are going to have to pay at least $958 a week, or $49,831. That is a big, big jump. And it may not be a big jump if you're a tech employer situated in Seattle, but if you're a nonprofit in Eastern Washington, this could be a really huge change. And I think it's going to be a change, really huge change for most businesses by the time we get to 2028. And we're looking at well over $70,000 to be an exempt employee. Quick note for those who have computer professionals who are exempt but paid by the hour. This is sort of a unique exemption. That hourly rate is also going up. It is going to be 3.5 times minimum wage by 2022. So what are your action items? Well, you need to start planning now for the change that is going to go into effect. You need to run a payroll report, look at all your exempt employees and see, is there anybody who is being paid below those salary basis thresholds? If so, you've got two options. You can either give them a raise effective January 1, 2021, or you can reclassify them as non-exempt. You can always do that. Even if somebody meets the duties test, you can always say you are non-exempt. But what that means is they're going to have to track their hours. And if they work more than 40 hours a week, you are going to have to pay them overtime. That is obviously not what most exempt employees want to be doing. That is a very big operational change. And so it's really important to be planning now to say, how are we going to deal with this if we have folks that are becoming non-exempt? And that same sort of planning needs to occur. You know, it may be that it doesn't hit you in 2021, but it is going to in 2025. So you want to think now about, how do I start to make the adjustments so that my business can be ready for this? Now, I gave a version of this presentation in February, and at that time, I really thought that there was going to be a lawsuit in Washington modeled on the federal one from 2016 that might at least delay all of this. But you know, the pandemic hit and the business community has a lot going on. So at this point, I really would say start planning. I mean, keep reading the news, but it's time to expect these increases to go into effect as scheduled. All right, we have one law down to go. So let's talk non-competes. Washington has a new non-compete statute. After years, the Washington legislature had been trying to restrict non-competes, and they finally did it in a law that passed in 2019 and became effective January 1 of this year, RCW 4962. So before we go through the actual restrictions, which are set forth on this slide, I want to skip to the next slide and just talk a little bit about what is a non-compete, what's covered under this new law and what's not. So the law has a very broad definition of non-compete, which is listed there under the first bullet point. The main type of non-compete, sort of the traditional non-compete, is you would see an employer have an agreement that says something like this. You employee, in exchange for working here or getting a bonus, during the time that you're employed and for a certain period of time thereafter, maybe 1 year, 2 years, you will not work for any business that competes with our business. Sometimes you would see those non-competes be limited in geographic scope. For example, you won't go work for a competing business within 25 miles of our Seattle store. So that is sort of the traditional non-compete that this law was primarily, I think, designed to limit. But the definition is so broad that it really could go into other types of restrictive covenants. And so there are certain things that are carved out from it, and let's take a look at those. So first of all, a non-solicitation is carved out. Now, what does the law define as a non-solicitation agreement? Well, it says that's an agreement that prohibits employees from either soliciting your customers or your employees. That is a pretty narrow definition of what a non-solicitation is. So certainly the traditional restriction that, okay, you know, if you leave, you can't for a period of 2 years after employment, ask my customers to follow you. That is going to be carved out and not governed by this law. But what about an agreement that says something like this? Because this is what I used to always write as a non-solicitation. It says, okay, employee, you cannot ask my customers to follow you. And even if they seek you out, you can't do business with them. So just don't do business with my customers. Leave them alone. I have certainly heard plaintiffs' lawyers say that they believe that is a non-compete and is covered under this law. And I think, frankly, if you look at the plain language of the statute, that there's a very good argument for that. It has a pretty limited definition of what a non-compete is. So don't just go by, if you have an agreement that says non-competition and a non-solicitation, you really need to read what's in those to figure out if they're covered by this new law or not. Also carved out from the new law are confidentiality and non-disclosure agreements around trade secrets or confidential information. That's good news. And then there's a carve out, it's not listed here, but if there's a sale of a business, this new law will not apply. So now that we understand for what a non-compete is that's covered, let's look back at what the restrictions are. So a non-compete is only enforceable if it meets these 4 conditions. First, the employee has to make over $100,000 annually. We are going to talk a little bit more about that $100,000 and how exactly to calculate it in another slide. Second, the non-compete has to be presented to the employee before the offer is accepted, or the employer has to provide extra consideration. That might be something like a bonus or a raise or a promotion, something extra beyond just continued employment. Now, when I first read this, I thought, oh, the law's not changing very much, because it always was the case that you had to have an employee either sign the non-compete before they started working, or you had to pay them something extra or give them, you know, some other benefit, some extra. You have to, it says you have to present the present the non-compete before the offer is accepted. And the reason for that is what they don't want is this situation. You offer a job, the employee accepts it, quits their other job, walks into the first day of work, and there sitting on their desk is a non-compete. Well, at that point, when the employee has already quit their other job, they don't really have much meaningful choice about whether to sign it. And so that's why the new law says you have to give it to them before the offer is accepted. So what I would advise you to do is if you have an offer letter, put it as an enclosure to the offer letter. Here's your offer. As part of your employment, you would be required to sign the enclosed non-compete. So that is restriction number 2. Restriction number 3, the term cannot exceed 18 months. So there is, a chance that somebody could go beyond 18 months, but for the average business, the average non-compete, it has to be 18 months max after they leave employment that the employee can be restricted. And finally, if the employee is laid off, the employer is required to pay the employee's base salary during the entire term of the non-compete. Now, that would be really expensive, right? You just pay a base salary for the year or year and a half that this employee is not working. What I've been doing in my non-competes is to write that, as an option, the employer has an option. If it lays off the employee, either they can choose to pay the employee for another year, or they can just say the non-compete is void and unenforceable. Now, will that fly under this new statute? Remains to be determined, but that has been my way of approaching it, and we'll have to see how the cases play out. So those are the 4 restrictions on non-competes. We've already talked about this slide, so let's jump forward to the minimum salary. We really want to make sure that everybody pays close attention to that $100,000, which sounds so simple and easy. First, that number is going to go up annually for inflation. I'm not sure yet where that new number is going to be published, but I'm guessing it will be somewhere on the Department of Labor and Industry's website. So check back with us and to see how that number increases. Second, the law defines the standard as how do you determine how much they're making? By looking at box 1 of the employee's W-2 for the prior year. Now, if the employee didn't work for you the last year, then you can annualize their current year's salary. But what's really important about that is that not everything goes into box 1 of the W-2. So for example, if the employee defers wages into a 401k, they don't go in box 1. So if you have an employee who is earning like exactly $100,000, that's what it says in their offer letter, chances are they may not actually make $100,000 for purposes of this law. So you need to take a second look at it if you have anyone who's earning something even close to that $100,000 margin. Now, there's also a number for independent contractors, $250,000. Really, I don't think there are many situations that you should have a non-compete for an independent contractor. They're kind of contradictory concepts. So, but do know if you are using a non-compete for a contractor, the number is more. Enforcement. Okay, folks, this law has teeth. If you have a non-compete that violates this law, even just by a little bit, and the judge says, your non-compete, it was 19 months instead of 18 months, I'm going to dial it back. You, the employer, are on the hook for a $5,000 penalty plus the employee's attorney fees. And that includes if the employee is the one who initiated the lawsuit to declare the non-compete invalid. Now, at this point, people may be panicking and saying, oh my God, but I had a non-compete that was signed years ago before this law ever existed. Am I in trouble now? No, probably not. So the law does have a carve out that if you have a non-compete signed before January 1 of 2020 and you're not trying to enforce it, the way I read the law, you shouldn't be liable for the penalty and attorney fees. Now, I've heard some very aggressive plaintiff lawyers have some crazy theories about how they're going to do it. So I'm not going to say there's no risk there. But the way I've been approaching this with most of my clients is to do a really individualized assessment. So we look at the old non-compete and say, okay, how important is it really to your business? How restrictive is it? Who has it? And then we come up with an approach of whether we actually go back and enter into new non-competes if we let employees know that it's not enforceable right now, or we're just kind of quiet about it and we wait till they leave and address it at that time. There's a whole variety of approaches you can take with regard to your old non-competes, but generally, be really careful if you're going to go to enforce them, but they shouldn't necessarily come to bite you. However, if you are entering a new non-compete after January 1, 2020, it better be in compliance with these provisions. So what are your action items? Well, first of all, as I mentioned, you need to look back at those old non-competes and see, are they going to be enforceable? Do we need to revisit them, renegotiate them? Have some sort of a letter that we give to people when they're leaving to say, we won't fully enforce this. You want to update your templates if you're going to have non-competes at all to make sure that they comply with the provisions of the statute. And then finally, really think about, do you need a non-compete at all? There are a lot of other types of restricted covenants, like a non-solicitation, like a good, well-crafted confidentiality and trade secret non-disclosure provision that may be able to protect the thing that you are trying to protect the most. And that may be a way better, safer, more enforceable alternative. So we really encourage you to, think hard instead of just having that reaction of course, I want to have a non-compete. All right, 2 down, 1 to go. So this is the overview of paid family medical leave, my favorite law. It has been a wild ride since 2017 when this law was passed to its full implementation on January 1, 2020. As an overview, if you have not been following the drama closely, what is paid family medical leave? Well, it is basically an insurance program that I think is easiest to understand if you compare it to unemployment insurance. So just like unemployment, if an employee loses their job, they go file an application with the Washington Employment Security Department, and the Employment Security Department will pay them a certain percentage of their wages for a period of weeks while they're job searching. For paid family medical leave, if an employee has a serious health condition or a new baby or they're caregiving, they can go file an application with the Washington Employment Security Department, who will pay a percentage of their wages while that condition is ongoing, 12 to 18 weeks. This insurance program is funded by premiums paid by the employee and the employer. It is mandatory, so there is a self-insurance option for employers, but very few employers are taking advantage of that for very good reasons, as we will discuss. So premiums, it's a total 0.4% of wages split between the employee and the employer. That number is going to go up to, I believe, 0.5% this next year. That's the latest I heard. I think they're still dialing it in. Still, it's not going to break the bank. It's split between employee and employer. If you are a small employer with fewer than 50 employees, you do not have to pay the employer's portion at all, but you do need to remit the employee's portion. You can also choose to pay the premiums on your employee's behalf. What types of leave are covered? So the types of leave fall into 2 main buckets. Family leave, so that is, well, actually, let's start with medical leave. So medical leave is the employee's own serious health condition. That is defined pretty much in the same way it is for FMLA, if you're familiar with that federal counterpart law. And then family leave could be bonding with a new child for either the birthing parent or the non-birthing parent. It could be caring for a family member with a serious health condition, and what we call military exigency leave. But if you have a military family member who's going abroad, you need to deal with that being deployed, some types of absences are covered. There is a much broader list of family members that is covered than under the federal law. So you will see the list here. Federal FMLA is just spouse, parent, and dependent child, whereas Washington paid family and medical leave includes parents-in-law, grandchildren, grandparents, and children, regardless of age or capacity. So how much will employees get? Right now, the maximum benefit is $1,000 a week. That also is going to increase. I heard it may be closer to $1,200 next year. But whatever the number, it is going to be a percentage of the employee's wages up to the maximum. And the percentage gets bigger as the employee earns less. The idea being that the lower earners should get more of their wages replaced overall. So the lowest earners can get up to 90% of their wages replaced, and that percentage decreases until an employee is earning around about $80,000. At that point, they are going to get the maximum weekly benefit of $1,000 a week. So if you have an employee who's earning $80,000 or $200,000, they're still only ever going to get that maximum benefit. That benefit could be paid for 12 to 18 weeks after a period, waiting period, which is sort of weirdly calculated, but it's not exactly a week. It depends sort of when your claim falls, but it'll be 7 days or less. So what does the application process look like? Well, this has been fascinating. So applications went live on the Employment Security Department website January 1. This program was built anticipating that they would have 6,000 applications a month. They got 20,000 applications in the first 3 weeks. So they were horribly behind in processing these applications. They have now, but I think in August, they finally caught up to a 2-week processing time. But it has been a pretty bumpy ride for employees that tried to get benefits in the beginning of the year. There's a 2-part application process. First, the employee is going to submit their initial eligibility application where they say, here is the type of leave that I'm going on. They'll upload a medical certification. And then once the Employment Security Department says, yes, you're qualified, check, they have to go in and file those weekly applications to actually say, I took qualifying time off, please pay me for this week. And that's what triggers payment. So again, very similar to the unemployment insurance process. Notice to employees, what do you have to do to tell your employees about this new benefit? Well, first of all, like every good employment law, there is a poster. They put it up in the nick of time. It was like December 27th, but the poster is now online, available for download. Nobody's going into your office anyways to see it there in the kitchen, but if you've got somebody going in, post it up. You can also put it, if you have like an online bulletin board, you can put it on there. Also, there is a specialized notice of rights to employees. You can also download that from the Paid Family and Medical Leave website. The link is there, and you need to give that to any employee who has been out for family or medical reasons so that they're aware of these benefits. So make sure to do both of those. So job protection, most of the questions I'm getting around this law, and now that we're in 2020, have to do with job protection. There is a different standard for employees to be eligible for benefits than for job protection. So that's sort of an interesting concept. But if for an employer to be required to hold the employee's job open, a few criteria have to be met. First of all, only large employers are ever going to be required to hold a job open. So you have to have 50 or more Washington-based employees before any job protection requirement applies to you. So if you're a small employer, your employees can still get benefits, but you are not required to hold the job open for them. Even if you're a large employer, to be eligible for job protection, the employee has to have worked for their current employer for at least 12 months, and they have to have worked 1250 hours during the 12 months preceding the leave. Now, be careful, of course, this is just job protection under this particular law. It does not, there could be other laws that require you to hold a job open. How does that interact with FMLA? It sure sounds similar. Well, job protection will run concurrently with FMLA if eligibility aligns. And that is not always the case. So we are at 12:30, but I'm going to very quickly give you an example of how that works. So let's imagine the scenario of a 2019 birth. Lucy Lucky gives birth in 2019. She takes FMLA leave for 12 weeks. And then January 1, 2020 hits. Lucy is smart. She files her paid family medical leave application. Well, she's already used up her FMLA, so those two leaves did not run concurrently. She gets 24 weeks of job protected leave related to that pregnancy. In contrast, if you have an employee who gave birth this year and they are on top of it and they file that paid family medical leave application right when they go out on parental leave for this baby, they start getting their 16 weeks of job protection. Those two leaves, FMLA and PFMLA, run concurrently, and the employee only gets 16 weeks of job protected leave related to this pregnancy. I am not going to go into supplemental benefits because we are already over time, but if you have questions about these, I am happy to take them. This is sort of my favorite topic to geek out about. If all of this makes you want to go the voluntary plan route, you can do that, but it needs to be approved by the state, and it is expensive. You are basically becoming an insurer yourself. So I would encourage you to give us a call if that's a route that you are thinking about going, so we can share our experiences. So far, only about 300 employers in Washington State have gone that route, but we do work with some of them. So finally, your action items. Of course, you should be experienced at paying those premiums every quarter now and filing your report. Get that poster up if it's not up already, and make sure that you're giving out the notice when you know somebody's going on family and medical leave. And finally, I really recommend that you get your employee handbook updated and make sure your managers are aware of this big new benefit. We don't want employees to go out on a family or medical leave and miss out on $1,000 a week, especially in these tough economic times, that they might be eligible for. So it's really important to make sure that your managers and the people on the front lines who really know why your employees are going on leave are aware of this information, so they can get them to the place where they find out about this law. So thank you so much for hanging with me. That was the lightning round of 3 big new laws. All right, thanks so much, everybody.